and distribution is the franchise and distribution section of the State Bar's quarterly meeting. I am Ben Minter. I am the acting chair of our section after our past chair, Meredith Barnes, decided to take a sabbatical from the practice of law to focus on her family. I'm on the executive committee for our section, along with Amy Andrews with Focus Brands and Ann Baruti with Bradley, Arent, Bolton, Cummings. And of course, I'm, as you can see from my background, the firm of Taylor English Duma. We are remote today. Normally, we would have an annual meeting in the summer, an in-person lunch meeting to conduct section business. The only section business we usually conduct is just to appoint a new member to the executive committee. As we've historically done it, we've shifted up where vice chair became chair, secretary became vice chair, and then the at-large member became secretary. We look forward to holding that in-person meeting come October. Might be September, but September, October. And at that time, we look forward to amending our bylaws also to allow for voting by Zoom, which we currently can't do. We are delighted to have speaking today Evan Sauda and Mark Vanderbroek with the Franchise and Distribution Practice Group at Nelson Mullins. Mark is probably well known to most of you in the state of Georgia. He is barred in Tennessee and Georgia. He heads the practice group there. Mark is also going to be speaking at the ABA Forum in Dallas this year on responding to and surviving negative social media reviews and online comments, which I have registered for, Mark. And Evan is a North Carolina litigator in federal and state courts there, including the North Carolina Business Court, which I'm learning a little bit about myself lately. Obviously, both franchise attorneys. We're delighted to have him here today to talk with to provide a case law and regulatory update for 2022 to 2023, which I think is an excellent primer for us all going into the ABA Forum for those of us that will be attending. If you have any questions, please submit them by chat, either generally or to me, and we'll visit those in the last 5 to 10 minutes of the presentation. So with that, Mark and Evan, floor is yours. Thank you very much for being here.
Well, thank you, Ben, very much. And thanks to everyone for joining us here this afternoon. What Evan and I are going to do today is we're going to have 2 parts of our franchise legal update program. The first part is going to summarize about a dozen or so court opinions that have been rendered in the last year and a half or so on franchise-related issues that we think are either important or educational opinions that illustrate application of various franchise law principles. And we'll also try to chime in with a few kind of lesson learned comments based on some of these anyway. Then after that, we're going to provide an overview of several threatened federal and state regulatory changes that could, if they're implemented, have a significant impact on the franchising business model. But we're going to start out here by summarizing 3 cases that were decided in the last, well, since 2022 by the 11th Circuit Court of Appeals. And it's kind of unusual to have 3 franchise cases coming out of one federal court of appeals in 1 year, but these are kind of some interesting ones. We'll start out with this Arrington versus Burger King opinion, which involved a franchise agreement, no employee poaching clause. And many of you will probably know that franchise agreements used to regularly include a clause providing that the franchisee was prohibited from hiring employees from other franchisees or from other company owned locations. And about, I don't know, 6 or 7 years ago, maybe some of the West Coast state regulators started looking at those and contending that they artificially suppressed employees' wages by prohibiting them from switching jobs as easy as they could. So they started pursuing some claims, and some lawsuits ended up being filed by private attorneys after that. This is one of those cases in which a class action was filed on behalf of current and former Burger King employees and former employees, claiming, asserting antitrust claims and alleging that the franchise agreement no hire provisions amounted to a contract or conspiracy in restraint of trade in violation of the Sherman Act. Burger King's defense was that it and its franchisees operated as a single economic enterprise, and thus that they were not capable of the type of concerted action that's required for a Sherman Act restraint of trade antitrust violation. For a monopolization claim, you only have to have one actor or economic enterprise, but for a restraint of trade antitrust claim, it requires two independent actors conspiring to engage in some kind of anti-competitive conduct. So in this case, the trial court agreed with Burger King's defense and ended up dismissing the claim on a Rule 12b-6 motion. Then on appeal, Evan, on appeal, the main issue presented to the 11th Circuit was, does the agreement at issue join together separate decision makers, being Burger King on the one hand and the franchisees, its franchisees on the other hand? In analyzing that, the court reviewed the franchise agreements themselves and noted that all the Burger King's franchise agreements said that the franchisees were independent contractors and that each franchisee was responsible for its own hiring and employment decisions. And based primarily on that, the 11th Circuit reversed the dismissal of these claims and held that Burger King and its independent franchisees were capable of undertaking concerted action in this case. And in reliance, they relied in that decision on a US Supreme Court opinion involving NFL licensing, in which the NFL had entered into merchandising license with a manufacturer and prohibited any of the teams from licensing similar merchandise from other licensors. And the NFL teams, the Supreme Court held, were separate independent actors from the league itself. And that was what the court relied on here. So while this case ended up being a loss for Burger King on the specific issue at hand, to me, there could be a silver lining here, because based on the rationale of the court that franchisees are independent contractors, I think this ruling could be helpful to franchisors in joint employment and vicarious liability cases. And I would certainly consider citing this case for the franchisor in those cases going forward. All right, the next case is Peterbrook Franchising versus Miami Chocolates. And here the franchisor Peterbrook decided to require its franchisees to install new point of sale systems. Franchisee Miami Chocolates refused to do that. They apparently thought their current system was fine and didn't want to spend the extra money. And so Peterbrook declared the franchisee in breach and then eventually terminated the franchise agreement when they didn't cure the breach. That led to the lawsuit in which Peterbrook alleged breach of contract and sought to enforce the post-termination non-compete. And Miami Chocolate claimed breach of contract in the form of a wrongful termination. Before the trial court, Peterbrook filed a motion for summary judgment, and the trial court held that the franchisee had breached the agreement and that Peterbrook was entitled to terminate. And so they granted summary judgment in favor of Peterbrook, the franchisor. It went up on appeal again, and the 11th Circuit did agree with the first part of the trial court's analysis. They agreed that the evidence showed that the franchisee had breached the agreement. But then they held that maybe the termination was a little too fast, because to terminate, you need not only a breach of the contract, but a material breach. And for a material breach, the non-performance must go to an essential part of the contract, and failure to perform a more minor part of the contract is not deemed material. So in considering the evidence in this case, the court again looked at the franchise agreements at issue and noted that the franchise agreements provided that compliance with certain terms of the agreement was deemed to be, quote, material, end quote. But the particular provision that allowed the franchisor to require replacement POS system and other equipment did not say that it was material part of the contract. The court also noted that there was some evidence that the franchisor had permitted some franchisees to use another POS system, and that Miami Chocolate's POS system had similar functionality to the one that Peterbrook wanted to put in place. So the 11th Circuit reversed the summary judgment here and remanded back to the trial court with this question of fact to be determined for trial. Was the failure to implement the POS system by the franchisee a material breach of the franchise agreement? While this was a temporary win for the franchisee, on remand, the trial court held a 2-day bench trial and then found that this breach was material and did justify the termination. So our takeaway from this case would be, you got to be careful in drafting your contracts. If you're going to declare in the franchise agreements that certain provisions are material, then there could be an argument by inference, as was made here, that other provisions that aren't expressly deemed in the contract to be material, you could find the franchisee to argue that means they're not. So you may be better off not necessarily declaring any provision of the contract as material and just leave that as an issue to be argued and decided in a dispute or in a lawsuit. The final 11th Circuit opinion is AFC Franchising versus Peruganen. AFC is a franchisor of urgent care clinics, and Peruganen was a master developer for that system that was developing franchises in the Connecticut and New York territories. They got into a contract dispute, and Peruganen sent a demand letter and notice of breach to AFC. And in response to that, AFC, wanting to pick its venue for the litigation, filed a declaratory judgment lawsuit in Northern District of Alabama, where it was based, seeking a declaratory judgment that it was not in breach of the contract. In response to that, Peruganen, of course, filed its own federal court lawsuit in Connecticut. And the parties proceeded then over the next 2 years to spend a lot of time and money and going through multiple district court and court of appeals opinions, litigating the issue of what was the proper venue in which this case should be decided. When the case finally came to the 11th Circuit, the question was the enforceability of a contractual floating venue clause. And this is one of those venue clauses that says all lawsuits have to be brought in the court of the franchisor's principal place of business without specifying a particular court. And I see these sort of floating venue provisions in a good number. I wouldn't say the majority, but I'd say a good number of the franchise agreements I've seen. And by the way, what happened in this case is that Peruganen's initial master development agreement was signed when the franchisor was based in Maryland. And AFC later acquired that franchise system, and their principal place of business was in Birmingham, Alabama. And Peruganen's argument was, hey, I never agreed when I signed the master developer agreement to litigate in Birmingham. Anyway, the court ended up holding that floating venue clauses were enforceable, at least in this context. So the Alabama venue was potentially proper. But the court further noted that their ruling would not necessarily bind the Connecticut court or the Second Circuit Court of Appeals in addressing their own issues and motions for venue-related things in this case. And in fact, in subsequent decisions in this case, it's now been determined that this case is going to proceed on the merits in Connecticut. Evan, I'm now going to turn it over to you to talk about some preliminary injunction cases.
Yeah, thanks, Mark. So we'll talk about 4 cases here in this section. We'll talk about 2 where there was a preliminary injunction or other preliminary relief granted, and 2 where it was not. Some interesting takeaways here. The first case we'll talk about is the JTH tax, which is Liberty tax. The Gilbert case that was in the Middle District of Florida. Here a franchisee was terminated because essentially the franchisee was allowing a employee to file clients' tax returns using the franchisee's individual federal income tax preparer number. The franchisor terminated the agreement for that violation, essentially, for the allowing somebody to use the preparer number. The court conducted an analysis of this, but the short answer to the use of the preparer number is that that's just like using somebody's bar number. It's a big no-no to be doing that. The franchisor, after some bad behavior by the franchisee, like refusing to allow the franchisor to, or attempting to hinder the franchisor in taking over the space, reopening as fast tax, refusing to allow the franchisor access to the space. The franchisor sued, seeking to enforce the non-compete provision, essentially to shut down this fast tax business that the franchisee had opened. And the franchisor sought a preliminary injunction. interestingly, the franchisee's response to that was to say that, well, us filing these returns, the filing of these returns by the employee using my preparer number, that was not a material breach, of the franchise agreement. The magistrate judge who first considered it, disagreed, said, look, that is a material breach of the franchise agreement for you to be allowed, essentially doing something that is illegal under federal law. That's a material breach of the franchise agreement that requires you to comply with the law. Magistrate entered a preliminary injunction. This reported case is actually the appeal of the magistrate's memorandum and order opinion. As you know, there's a pretty high bar to get a district judge to throw out a decision that their magistrate has entered. And the court here fundamentally agreed with the magistrate, overruled the objections, and entered a preliminary injunction, enforcing the non-compete here, finding the non-compete was narrowly tailored and given its activities geographic scope, and then it was a 2-year non-compete. So that was the situation where the franchisor here was able to prevail, getting a preliminary injunction to enforce the non-compete against what I think you could probably characterize here as a somewhat rogue franchisee following or I suppose rogue ex-franchisee. So the next case here, it's the Housemaster v. Burke. Housemaster is a home inspection franchise. And this case fundamentally has to do with expanding the non-compete provisions in a franchise agreement to non-signatories to the agreement. That was really the fundamental issue before the court here. The facts in this are somewhat interesting. The franchisee initially started the business with his then wife, and then he took it back over, and then he sort of turned it over to his second wife to run. And then he had these, 2 other folks that had been in the business for a long time that were non-signatories to the franchise agreement. The fundamental point, as the slide says, of where this franchisee was terminated was because he had a side business called Burke Inspections, and he was taking inspections under Burke Inspections and not running through Housemaster, and the whole thing, as it just was not run well from the franchisee sort of compliance perspective, which ultimately led, as it often does, to the franchisor's termination of the franchise agreement. And the franchisor found out ultimately as well that not only was the franchisee to some extent participating, the former franchisee, but his wife and these 2 employees had sort of set up a competing company, and the franchisee was doing some work for this competing company after the termination. So here the court kind of looks at all of those facts and says, well, I think that the court says when you have the former franchisee and he's got the ability to direct these folks to operate this competing business, we can enforce the non-compete and non-solicit not only against the signatory to the contract, but these non-signatories to the contract. So this one I look at, and as we all know, these can be very fact-dependent inquiries, fact-dependent analyses. And the question that comes to mind for me on this one is, well, what if instead of these relationships, if these had just been employees of the franchise? I obviously think in that position, you're much harder pressed to convince a court that it should extend sort of this non-compete and non-solicit obligation to people who were nothing more than employees. But to me, the lesson here is that, I think, and as we've all seen, a court's going to look and see sort of what the real relationship is here. And I think here the court felt like there was enough of a tied in relationship with this fellow's wife and these employees that the court felt like it was going to be comfortable imposing these obligations on them. So the next matter, it's another liberty tax matter. This is the Anderson. This is out of Arizona. The franchisor here terminated the franchisee after they gave notice of non-renewal. Their claim was that the franchisees were directing tax filings to related companies. And that they had claimed that, when the lawsuit was ultimately filed, that there were non-signatory defendants to the franchise agreement that were working with the franchisee to open competing businesses in former franchise locations. So when the lawsuit was filed, right, you had two groups of defendants. You had the actual signatories to the franchise agreement, and then you had these non-signatories. That's the third bullet there. The signatories to the franchise agreement agreed to the temporary restraining order. They said, "Look, we agree that you're entitled to this. We agree that we can't do this." The non-signatories did not. The non-signatories fought the imposition of the preliminary injunction. And here, as the court walks through its analysis there in denying the non-signatories, what the court really found determinative, right, is, at this stage, you've got to prove up to get your preliminary relief, right? You're trying to clear the bar of likelihood of success on the merits. And it's not sufficient to simply rely on the allegations in your complaint to not put forward any proof here. Really the only proof that the franchisor put forward that the court cited in its opinion was it said, well, the franchisor has pointed to this correlation in terms of, there being a total pool of tax returns. And, at the beginning, they were mostly at JT8, or they were mostly with Liberty Tax. And now they've opened these competing businesses, and our returns have gone down by 4,000 and they've done 4,000. The court didn't find that to be sufficient. Obviously it's a fact-based inquiry. To me, that would be that would be compelling, but I can also see how without more, the court would say, well, I don't think you've shown, likelihood of success on the merits just by bringing me sort of some allegations and one good fact. Here, that's denied. I mean, the takeaway here is, right, I mean, if you're, the phrase is, if you're going to strike at the king, you'd best kill him. Because we all know, if you start early in the case and you get your TRO and your preliminary injunction denied, that we sort of all forecast where that means your case is likely going, and that the judge has already sort of expressed that you're not likely to succeed on the merits, which can obviously change the strategy going forward. This final case is actually, to Mark and I, it's one of the most interesting cases in this section, in the preliminary injunction section. Here, Subway had discovered that their former franchisee was opening a restaurant with a name, Your Way Subs, which is problematic in a number of ways, from a trademark type perspective, service mark type perspective. The franchisee goes after the former goes after the former franchisee, basically says, look, you're using our IP here. We're not able to get a new franchisee into this territory, and you're kind of emboldening these other franchisees to do the same thing. And so interestingly here, the court focused on the provision in the franchise agreement that Subway had with this franchisee that basically assigned liquidated damages for breach of the former franchisees non-compete. And it set out there was a formula in it by which you could calculate the damages that were owed. And the court looks at that liquidated damages provision. And the court said, well, you've put a dollar value on this. And because you've put a dollar value on this, right, money damages are sufficient here. And for that reason, your preliminary injunction is denied. And obviously, I think for the franchisor, that's a less than ideal outcome. But I mean, obviously, the cautionary tale here is that if you're going to assign a liquidated damages number to any breach of a franchise agreement, you run the risk that a court will look at that and will say, you've assigned a money damages number to this breach, right? Ergo, it's compensable with money. Ergo, you get no preliminary relief. So that is sort of our takeaway here, is that, you know, that's a drafting pointer that, or at least an issue that you would want to consider as you're drafting an agreement, is that the liquidated damages, while certainly helpful in many, many ways, does open up the risk of not being able to obtain a preliminary injunction.
And adding on to that, Evan, in my experience, I frequently see liquidated damages, as I'm sure you all do, in franchise agreements to cover early termination damages in the event of breach, to avoid having to prove actual damages. I don't very often see liquidated damages as a remedy for breach of the non-compete. And my guess is that after this decision, Subway's franchise agreements probably no longer have that liquidated damages clause in them either. Okay,
Yeah.
We're now going to move along and talk about a couple of cases involving allegations of fraud and franchise disclosure violations by the franchisor. The first one is one of what has been a series of lawsuits that franchisees have filed against the I Love Kickboxing franchisor over the last several years. And this was filed by a franchisee that had opened a kickboxing studio in Arizona, operated it over a year and a half and was losing money the whole time, and then shut it down and filed a lawsuit against the franchisor alleging fraud and franchise disclosure violations. And the bullet points I've got listed here were the main areas in which the franchisee alleged that there were fraudulent misrepresentations made, including that the FDD was not registered in New York, which is a franchise registration state that was applicable to this sale. They didn't disclose litigation in their FDD, even though there was some, but their billed out expenses were going to be less than $147,000, and then they allegedly made various financial performance representations outside of the FDD. Franchisor filed a motion to dismiss, and the court ended up denying most, but not all, of the franchisor's motion to dismiss. They denied the motion with respect to all the fraud and disclosure violation claims that we've got asterisked here. And for those particular claims, the court found that properly alleged sufficient misrepresentations of historical facts to support a fraud or disclosure violation claim going forward, at least at the motion to dismiss stage. The items that are not asterisked here are ones where the court did grant the motion to dismiss. They dismissed the state franchise registration violation claim because the statute of limitations had passed by the time the franchisee filed the lawsuit. And then they dismissed two of the claims about financial performance representations being made outside of the FDD because the court held that they were unactionable projections or predictions or opinions about things that could arise in the future, and not misrepresentations of historical facts. And generally, as you know, to support a fraud claim, you've got to have misrepresentation of facts and not opinions or future predictions. In the next case involving Travelodge, fraud was raised by the franchisee as a defense to the franchisor's breach of contract claim. Here, franchisee signed up with Travelodge for a 15-year franchise agreement. But then after 1 year, ceased to operate as a Travelodge, which led to Travelodge terminating the franchise agreement for default. And they then filed a lawsuit and sought summary judgment seeking an award of early termination liquidated damages. Now, the court ended up denying the summary judgment motion here, finding that there were disputed material facts on two of the franchisee's defenses. And the first one involved a fraud defense that the franchisee alleged, and apparently must have submitted at least some evidence to support, that during the negotiations of the franchise agreement, Travelodge had told the franchisee that, hey, if the Travelodge thing doesn't work out, we'll let you rebrand to another one of the Wyndham hotel brands. And apparently there was also some evidence that when the franchisee requested that later, Travelodge turned down that request. So the courts found that was sufficient at least to get past summary judgment on that fraud defense. And there was also evidence that Travelodge had delayed in granting the franchisee access to its central reservation system by several months, and that could have contributed to the problems that the franchisee had in its operations as well. So summary judgment was denied to the franchisor in this case. I'm going to now turn it back over to Evan to talk about a couple of cases involving everybody's favorite topic, joint employment.
Yeah, so a couple of cases. This is, I jokingly about this case say that, the Patel case, this is just the yearly update on it, because I'm sure there'll be another one next year, although this does seem to be heading towards its conclusion. As I'm sure some of you know, the Patel v. 7-Eleven case fundamentally had to do with whether the 7-Eleven franchisees could be considered the employees of 7-Eleven. This case has sort of a long sordid history, but in the last year, basically, it was up to the First Circuit on the issue of, well, what's the proper test, right, for determining whether or not somebody is an employee, right? You've got the Massachusetts independent contractor law, you've got FTC guidance on it. Which of the two applies? So the First Circuit sort of punts this to the Massachusetts Supreme Court. The Massachusetts Supreme Court goes back to the First Circuit and says, hey, we've looked at this issue. We think that the ABC test applies, which is the Massachusetts independent contractor law, right? So the First Circuit says, okay, sends the case back to the district court for application of the prongs of the Massachusetts independent contractor law to the relationship, right? And then, as courts are wont to do, the district court sort of sidesteps this in a very interesting way, right? So the Massachusetts independent contractor law basically, before it lays out the test, it says, well, it applies, that this application this test applies to a person who provides a service, right? So the court, without getting into the prongs of the ABC test, sort of analyzes the franchisor-franchisee relationship here. And they say, well, here, franchisees, right, do not provide a service to 7-Eleven, right? It goes the other way, right? That 7-Eleven, as the franchisor, is providing services to the franchisee for which the franchisee pays 7-Eleven, right? You get the use of branding, you get the use of guidelines, you get all of the things that a franchise agreement provides. And so the court just says, well, 7-Eleven is not, the franchisee is not the person who provides the service. 7-Eleven is the person who provides the service. And because of that, the court don't need to go through this analysis. I can just hold that here, the franchisees are not employees. They don't even fall within the test because they don't provide a service to the franchisor. So that obviously big win for 7-Eleven, for the franchisor there. And it remains to be seen, how this impacts sort of the full scope of these 7-Eleven employee cases. Here's this next slide here is a related one. It was a Ninth Circuit decision. Similar posture here, right? But at trial, the franchisor prevails. Trial court holding that the franchisees are in a different line of business, and that the franchisees, as I would say most franchisees do. They hold themselves out, as independent business owners. The franchisees appealed this to the Ninth Circuit, and they said, well, rather than applying this older test that you applied, the district court should have applied the ABC test, which is the same test as the Massachusetts independent contractor law. And the Ninth Circuit, again, agreed, said, well, for claims that arose after 2020, right? They were governed by California. The bill was AB5, and they should have been subject to the ABC test for any claims arising after 2020. The court sort of agrees, says you should have applied the ABC test, lower court. But then they said, well, the lower court provided such detailed findings of fact that we don't need to send this back down to the lower court. The lower court has provided sufficient facts, within which we can find that the ABC test did not apply here. The factors are already enumerated, the findings are already made. So we are going to affirm the lower court's ruling here on the determination of the proper tests to apply.
So good news, two wins for franchisors on the joint employment issue last year.
That's right. Those are good. Those are good cases. But I think it's a little unsettled. We'll talk here. This is the sort of the start of our regulatory update, at least at the federal level. So as I'm sure a lot of you know, the NLRB is, and to some extent the Department of Labor as well, are in the process of sort of redefining the independent contractor versus employee rule. And the new rule, essentially the big difference there between the current rule and the new rule is unexercised control, right? It could be sufficient to find somebody an employee, right? If you have the ability to control what someone is doing, even if you don't exercise it, that person could be considered an employee. You see the other non-exhaustive factors there in the new rule. This is the latest in sort of a long saga about the rulemaking that happened with Obama, going back to the Obama administration, and the Trump administration tried to undo it, and then there was litigation about it, which has since been mooted by the new rule. But the new rule obviously would have consequences for franchisors. There's a very in-depth article about this in the most recent Franchise Law Journal that's very good, that I would commend to all of you. I think that article, it provides a very good overview of the NLRB and DOL actions, and then sort of describes some of the potential consequences to franchisors. It goes into this in great detail. And if you're interested and concerned about these issues, and I think everybody should have that on their radar from both franchisor and franchisees. I think that's a very good deep dive into that and some of the potential consequences that could happen with this rule.
And we've got one more court opinion to summarize here before we go back to the regulatory summary. This one involves the issues of relating to breach of contract and breach of the duty of good faith and fair dealing. Here, franchisor Remax ended up terminating a franchise agreement after the franchisee made an allegedly unauthorized office relocation. And as a result of that, the franchisee actually sued, claiming wrongful termination. And it filed a motion for preliminary injunction to try to enjoin the termination subject to the dispute being litigated. And in this case, the franchisee actually prevailed in getting the court, a New York State trial court, to grant a preliminary injunction to enjoin the termination. Meanwhile, after Remax had terminated the franchisee, they removed the franchisee from their regional website that listed all their franchisees in the area, and removed them from other advertising they did. And they did not put the franchisee back up on the website or the other advertising after the preliminary injunction was issued. The franchisee ended up ceasing to pay fees and eventually closed the office and just shut down the business. And RE/MAX ended up suing them, seeking damages and attorney's fees. The trial court ended up awarding RE/MAX damages and fees, finding that the franchisee breached the agreement. But on appeal this time, it went up to one of the New York State Court of Appeals. And again, as in some of the other 11th Circuit cases we had looked at earlier, the appeal court reversed. They noted that because of the preliminary injunction that had been entered prohibiting termination, the franchise agreement actually continued in place pending the rest of the litigation. And therefore, it was actually RE/MAX and not the franchisee that had breached the franchise agreement when RE/MAX discontinued listing the franchisee on the website and advertising. And the court further found that that material breach by RE/MAX justified the franchisee from basically treating the contract as terminated and closing down the business. So the court held that RE/MAX was not entitled, of course, to any damages or fees. And the one saving grace for RE/MAX, I suppose, did find that RE/MAX was not in contempt of court, given the more stringent standards that you have to prove to find someone in contempt. But I think the lesson here for franchisors is, hey, you've got to make sure you continue to comply with franchise agreement obligations until you're sure the contract is terminated. And obviously here, if a court says that it's not, you need to go back to complying with whatever it is you need to provide as far as services to the franchisee. All right, we're now going to move back to the regulatory development front. And this is really a good news, bad news situation, with the bad news being that there's currently more threatened changes to federal and state regulations that would negatively impact franchise relationships in the franchise business model than really any time I can recall during my 35 years or so practicing law. And the good news is, at least, is that so far these regulatory changes are only threatened and have not yet been fully implemented. However, that could change very quickly. The International Franchise Association has been actively involved in opposing all of these proposed regulatory changes we're about to talk about today, including the independent contractor rule that Evan talked about earlier. A couple of the other important federal regulations that are being considered. The FTC, as many of you know, is recommending the unenforceability of most non-competes, which would be a big change in the current law. And this law these proposed regulations rather broadly defines workers as any natural person working for an employer. That would include independent contractors. And to my knowledge, I've not looked at the complete proposed regulation, but I've been told that there's no exemption for key employees or management employees or anything like that from the definition of workers. Now, the proposed regulations do provide that they would not apply to franchisees. So a franchisor could still have and presumably enforce a non-compete against a franchisee if it was reasonably restricted in scope. But the regulations would apply to employees of franchisees and employees of franchisors. There is an exception, as would be expected, that the regulations would not apply to the seller of a business who could still be made subject to a non-compete. The last I saw was that the FTC had announced it was going to wait until, I believe, April of 2024 to issue whatever regulatory changes they're going to. So let's hope they don't do too much here. The FTC is also in the process of reviewing and considering changes to its franchise rule, which would be the first changes since the 2007 amendment to the franchise rule. And along with that, it is also sought comments on, and this is a quote from the provisions that was issued by the FTC on, quote, franchisors exerting control over franchisees and workers. So you can kind of see where their leaning seems to be on this. And they've included a list of things that they are looking for comments on, which include the few I've got listed here, such as the franchisee's ability to negotiate franchise agreement, the franchisor's ability to unilaterally change the franchise system. And this relates to, of course, the typical provisions, you almost always see that a franchisor is entitled to change its manual and change its standards and procedures and requirements in its operations manual, and the franchisee is required to comply with that without having to formally modify the franchise agreement. It also covers, these other items listed here, including payments to franchisors from suppliers relating to franchisees' purchases. Again, the IFA and others, including many franchisors and franchisees, have been weighing in on these changes. They'd appreciate any weighing in that the franchise lawyers want to make too. There's likely going to be some changes made to the franchise rule relatively soon, but hopefully it won't be anything too extreme that would have too much of an impact on the franchise business model. There are also state regulatory changes being considered in primarily in California, which is always the state of most concern. Many of you are aware of the California FAST Act, Fast Food Accountability and Standards Act. It actually was passed by the California legislature and signed into law by Governor Newsom in 2022, but the implementation of it is halted per a court decision pending a 2024 voter referendum on the issue. The IFA and other organizations were able to get enough voter signatures in California to put it up on a referendum. It'll be voted on next year, but this act, if it goes into effect, would apply to any restaurant or fast food chain with over 100 stores nationwide and a common brand. You would combine for franchise systems, franchisor and franchisee stores nationwide for that determination. It sets forth a fast food industry council that could set wage and labor standards and would suggest potential minimum wage increase up to $22 an hour. And so again, this is halted though pending a 2024 voter referendum. But in the meantime, and not shown here, the California legislature is considering a bill, AB 1228, which frankly would be even worse, it sounds like, than the FAST Act, and would expressly impose joint employer liability for fast food restaurants in California, and as well as imposing other vicarious liability on franchisors for franchisee violations, accidents, or whatever, employee claims or claims from third party. That has not passed yet, and is being actively opposed. Finally, many of you are aware that the National Association of Security Administrators put out some guidance that limited and suggested limiting franchisee acknowledgements and questionnaires that franchisors commonly have franchisees sign in connection with franchise agreements. So far, that NASA limitation has been adopted by California and Maryland, and my slide here says Washington was proposing implementing it. I think I've read since then that Washington has adopted it also. My guess is that all the franchise registration states will eventually adopt this, and I think franchisors are handling this in different ways, including for some franchise systems having a separate FDD for the non-franchise registration states, where you could continue to have these sort of acknowledgements that may not be permitted in franchise registration states. And then finally, that's the end of our formal legal update and regulatory update, but we did want to throw in this just because we thought it was interesting, a list that the Franchise Times had published earlier this year of information they gleaned from item 3 of the top 10 franchisors in the country. I think it was by number of units, although I'm not.
It was by sales. It was by system sales, I think.
Oh, was it by sales?
Yeah.
Okay. Anyway, we just thought it was kind of interesting that the range of numbers of lawsuits filed here, between the low of our local Chick-fil-A here of having 0 lawsuits disclosed in item 3 to the high of Subway having 125. Although again, given the number of franchise units that some of these systems have, then the number of lawsuits disclosed, I suppose, are still a relatively small percentage of the overall number of units.
Yeah, and these are just item 3 disclosures too. So this would only capture franchise or franchisee litigation. But I mean, none of these, as Mark and I have sort of studied this, I mean, none of these numbers are, insanely high. I mean, obviously Chick-fil-A, KFC stick out as being particularly low, but none of these look particularly active.
So that will wrap up our update, but we are certainly available to answer any questions that people may have.
Thank you, gentlemen. It certainly impresses upon me, and I think everyone else, the importance of making sure we edit our franchise agreements and FDDs to keep up with changes in the law, particularly case law. Evan, I am curious, since you practice in the North Carolina Business Court, Georgia has a relatively new business court, but it's pretty high threshold, monetary threshold to be in that. Do you see franchise disputes in that court often, or
it would be, so the North Carolina Business Court, the jurisdiction of the court, it's not strictly a monetary threshold. You can get there if both parties agree and it's a contractual dispute that's in excess of $1 million. But, just if you didn't meet that threshold, you probably could not qualify for one of the mandatory jurisdictional items to get into the business court. You could, if it were, a dispute that involved sort of ownership of a company, or some sort of something along those lines. But the way the guidance of the business court, the jurisdictional statute works, a franchise dispute would not ordinarily end up there, although some do in a variety of other ways. So, I mean, there are franchise disputes pending before the business court, but it is not, I would say that it would be the exception that a franchise dispute would end up there rather than the norm. That's a longer discussion about the kind of interesting way that the General Assembly here in North Carolina decided to extend the business court's jurisdiction. I wish they would make it larger, because I'd love to be able to just put large contractual disputes in there. And the North Carolina courts, you don't get assigned a judge unless you're in the business court. So, you want to file a motion, somebody who knows nothing about your case is going to hear it. So I hope they expand that, but as of now, that's a difficult thing to do.
Ben, if I could follow on with respect to some of Georgia's business courts too, I actually am involved in a current lawsuit between a franchisor and a large multi-unit franchisee that involved termination of about 50 franchise agreements for the franchisee. And the case was filed initially in Fulton Superior Court, and it's recently been transferred actually to the Fulton County Business Case Division, where we will be proceeding going forward.
right?
But there's a given the number of franchise agreements at issue, there's a lot of money in this in dispute, and be some pretty complex issues to work through on the legal and factual issues.
Gotcha. I was prompted, a question came up in my mind when you were talking about the federal regulatory framework and how they were, the feds were soliciting comments for the franchise rule. And I just wondered, is there, or do you suspect there's any kind of overlap or connection between the proposed rule changes regarding joint employer non-compete and what the comments that they're soliciting regarding the franchise rule?
Well, I would say they involve separate issues, but I think there is a little bit of overlap in that I think they both reflect I guess, perceived concern by the current makeup of the FTC and the Biden administration that the so-called little people or the little folks, either the employees or franchisees, maybe don't have equal bargaining power with their employers or their franchisors, and perhaps they may be looking, even in connection with potential changes to the FTC franchise rule, to provide what they may consider to be some additional protections to them. But the problem is, at least when it comes to the FTC franchise rule, how much those regulators really know about the franchise business model and how it works and how even franchisees, consider themselves to be business owners.
Mhm. I was wondering if we could maybe anticipate looking the magic 8 ball and see what might be coming concerning that franchise rule. And also regarding California, do y'all know of any, or have you spoken with any clients that have thought about how they might react to the FAST Act, or any thoughts about how people might try and get around it? I don't know, through some master franchisee relationship, or is everybody just crossing their fingers?
Yeah, I mean, I have not been advising any clients specifically regarding that. I have read and certainly heard certain franchisors or representatives of franchisors, wondering whether it's still worth it even trying to do business in California. Of course, that's a large state, but boy, the risks to a franchisor, particularly if that AB 1228 law got passed, where all fast food restaurants were considered, joint employment situations for franchisors, that would change the ball game in that franchisors, would all of a sudden have potentially thousands of employees in California that they didn't know about previously, that were actually employed by their franchisees.
I mean, at that point, why are you right? I mean, at that point, why are you even franchising? You're company owned at that point, right?
Right. And then one last question. One of our viewers is wondering if the liquidated damages clause in the Subway case included language that reserved rights to equitable remedies in addition to the liquidated damages.
Let me pull out the court opinion. So the opinion that the portion of the agreement that the court quotes in its agreement, it does say that doctors, associates, or an affiliate may also bring an action in any court having jurisdiction to seek damages, injunctive relief, or both. That does not talk about you expressly, the language we often see sometimes about you expressly agree that this is going to cause irreparable harm. But that it did at least recite that in the language.
Okay. Well, gentlemen, thank you very much. This presentation has been recorded and will be available on the State Bar's website, the section page website, and I think will be available via ICLE in the future as well. Again, Evan Sauda. Evan, I do have to ask, in North Carolina, is it often pronounced Sauda, or do you get Sauda most of the time?
I get Sauda the most. There's a town in North Carolina called Saluda, so sometimes I'll get that.
Well, and so yes, we had Mark Vanderbroek and Evan Sauda from Nelson Mullins Franchise Practice Group. Thank you both for being here. And gentlemen, I imagine your email, of course, your email addresses are here. So if anyone were interested in the slideshow for today's presentation, I'm sure they could email you for a copy of that. All right. Well, thank you. And I hope everyone has a great day.
Thanks, everyone.
Ladies and gentlemen, this does conclude today's meeting. Thanks for joining and have a great day.